All right. Good evening, members, and today is the 20th of April, and we're having a small presentation on arbitration in civil and structural engineering projects. Our guest today is Engineer Howard Ashiundu. Right now, I would like to hand over to him for him to take us through the presentation. Howard, welcome.
Thank you, Ndolo, and thank you, Lawrence, for organizing this webinar. I must say that it's a great privilege to give me the chance to share with the colleagues in the industry about the topic of arbitration. I had wished to perhaps have only 10 slides so that we can fit in within the 45 minutes. I think in total, the slides that have got content for sharing is about 20, but that should not worry us because I'll try to make it as basic as possible, taking us through basic definitions, the things that we need to understand about arbitration at the very, very basic level before we can shift our attention to thinking about arbitration in the construction industry, that is in civil engineering industry and structural engineering industry. I chose to understand these civil and structural engineering projects as both projects spanning infrastructure sector, which are managed 100% as civil engineering projects, mostly governed by FIDIC forms of contract, but also including structural, especially in the building industry, or projects which are mostly governed by the JBC contracts. Those are projects which are done jointly together with architects and quantity surveyors. Arbitration is an interesting topic. Basically, the easiest way to define it is a process of dispute resolution in which a third party or neutral arbitrator renders a decision after a hearing at which both parties have an opportunity to be heard. But the easier way to understand it is that it is a quasi-judicial process. It's more or less the way judiciary handles cases, except that in arbitration, we do not follow the rules of the court strictly, in the sense that, if you go to a court, it's a rigid system. It has a judge, and the person who sits on the bench must be duly admitted according to the laws of Kenya or indeed laws of any other jurisdiction. And the people representing the parties must be advocates admitted to the bar. So you cannot have just anybody representing you in a court of law, neither can you just have anybody listening to your case. The difference in arbitration is that whereas the sitting and the procedures might look more or less the same, all of them follow the civil procedure rules, the significant difference with arbitration is that the arbitration normally will have a lay jury and lay counsel. Lay jury because the person sitting as the arbitrator or as the judge does not necessarily have to be admitted to the bench under the normal laws that admit judges to the bench. This gives an advantage to arbitration in the sense that a person sitting as an arbitrator, practicing the powers of a judge, a high court judge actually, can be a person from any profession ranging from legal profession, or it could be a person from a technical profession, say an engineer or an architect, exercising judicial powers of a judge, but within the confines of the law of arbitration. Something that is fundamentally important is that in arbitration, the the people preside over it, both the council, both the council and the lay jury, usually selected by the parties. And the arbitrators, the bench, the people who sit to listen to the case will usually be a panel or an individual who is agreed upon by the parties. We shall be seeing a lot more as we go forward about arbitration and just how to come up with a panel that listens to the issues that are brought before it. Several people have tried to give different other definitions of arbitration, and I've shared with it. Someone called Brenda says it defines arbitration as the process where a single or panel of persons imposes a settlement on parties in dispute. Or the third party who is imposing this decision must be neutral, he must be impartial. The decisions that he renders are legally binding. The procedures are almost similar to those of a high court, and the hearing is private, and venue and time is the convenience of the parties. Okay. Now, arbitration as practiced locally is governed by the Arbitration Act 1995 in Kenya, but you realize that many other countries have also legislated arbitration acts in their country, but internationally, we have nations or authorities, countries which have practiced arbitration for long, who have perhaps modeled their systems so that many other countries usually borrow from them. But internationally, under the United Nations, we also have the UNCITRAL model law, which is the law of arbitration and a reference document to many other countries who would perhaps want to develop legislation for arbitration in their own jurisdictions. They would borrow heavily from the UNCITRAL model law, but make adjustments to fit in their respective countries. The UNCITRAL model law, basically developed by the United Nations Convention, governs international commercial arbitrations, but we also have other pieces of legislation like under the ICC rules, under the Chartered Institute of Arbitrators UK. They have also developed rules that govern arbitration, and they have established laws within those systems that we can always make reference to whenever we are conducting arbitrations. Quickly, I would like us to look at advantages of arbitration, because I think this is the gist of it's the gist of the presentation today. One of the important aspects of arbitration is that the person who sits to listen to the dispute has got the advantage of knowledge in the subject matter. And the best way to elaborate this is that when you take a dispute about construction to a court of law, you might submit the dispute before a judge who has studied law and perhaps is a professor of law. It will take you many hours trying to help the judge understand what geotechnical investigation is, because he has no knowledge in the subject matter. However, if you had a dispute about collapse of scaffolding on a construction site, on a building site, and presented it before a structural engineer who has studied arbitration and who understands the confines of the laws of arbitration, by the time you are explaining that there was a mud seal, there's a mud seal on the scaffolding which was not properly done, you do not have, for example, to carry the engineer to site, demonstrate to him, explain to him, elaborate, and consume hours trying to help him understand the subject matter, because a person who sits to listen to the dispute, the parties have got the advantage of selecting someone who has understanding of the subject matter. And this makes it easier for the person first to internalize the issues that are under dispute, and therefore be able to apply the law in a manner that is fair and impartial to determine the dispute and get the parties to move on with the work. So expertise is one of the biggest advantages of arbitration. Secondly, mention speed. When you have to subject your matter or your dispute to court, you have to go at the pace of the court. If the court says today is a mention and we are not going to sit down to listen to your issue, you have no other way of making or compelling the court to hear your matter yesterday. Your matter has to be heard the day and according to the calendar of the court, which is a rigid system. In arbitration, it's interesting. One of the areas that I've found to be the best example of speedy delivery of justice in arbitration is in sports arbitration. You know, if you are having an athletics event, say Olympics, and we have two athletes who crossed the finish line this evening, say it's 8 in the night. Normally, there was something that the two athletes are disputing about. One of them perhaps feels like the other one touched him inappropriately, making it difficult for him to finish in the position they should have finished. So he feels that the other athlete is supposed to be punished. Now, in sports arbitration, the matters in sports arbitration, some of them are settled in a period as short as 24 hours, because by tomorrow, by the next day, the medal is supposed to be given to the winner. So there is no much time to sit and begin back and forth, consuming time the way it happens in a normal court process. And this ensures that parties are able to receive justice impartially, but also expeditiously. So arbitration gives you the advantage of speed, as opposed to if you are to report the matter to court and spend hours and days trying to develop the documentation. Because arbitration is flexible and it always proceeds according to how the parties have agreed, because the parties usually have the autonomy. Most importantly, arbitration gives the advantage of privacy, because if you take your matter to court, you have no way of stopping people from poking their nose into the issues. People should be able to hear, follow. Media will be allowed into the court and get your matter cleaned out there. You clean your linen. We say cleaning your linen in public. So privacy, and one of the reasons why many businesses, many contracts will prefer to go for arbitration. One of the reasons why many people would prefer to go for arbitration is to get privacy, because you can maintain company secrets, you can maintain business confidential issues about your businesses, because it is the parties who agree. We want our matter to be heard under these conditions at this location, and only so and so will be in. And after the dispute has been heard, the arbitrator is not at liberty to speak out there or to talk about the arbitration or to publish it. It is only within the powers of the parties to decide who gets to see, who gets to know, who gets to who gets to find out what it is that happened. So many businesses will prefer to go the arbitration way so that they can maintain the confidentiality of the issues that they would not want to be aired in the public. You can imagine if a company like Safaricom was taken to court because of a matter where some 200,000 shillings got lost on an M-Pesa transaction. They would prefer such a matter to be heard through arbitration. Everything can be plainly put on the table. The problem can be found where it is. They can compensate the person and quietly exit the scene without having to suffer the damage of bad publicity, which could cause the company to lose a lot more as far as business is concerned. Arbitration is convenient. We've just said that everything is done according to the party agreements, and then it's also believed to be less costly. However, the issue of cost has been argued. On one side, it's argued that you do not have to pay the judge, because if you go to court, you do not need to pay the judge, but you'll pay your advocate. But then advocates will take forever canvassing your case, making the cost of your case to go way up. However, in arbitration, despite the fact that you are the one who pays the judge or the arbitrator, normally because of expeditious resolution of the matter, because of privacy, and because of the other advantages I've mentioned, the cost ultimately will be found to be much lower as opposed to going through a court process. So cost is one of the advantages of arbitration that have been argued from both sides. Then finally, we said it's flexibility. It has flexibility, and it has enforceability. If an award is granted by an arbitral tribunal, that award is enforceable. I need us to understand that the powers exercised by the arbitrator is equated to the powers of a high court judge, so that an arbitral award, normally if it's taken to court for enforcement, it will usually be taken to a judge at the level of a judge. It never goes below that. It can never be taken to a magistrate. And the powers that arbitrators exercise, despite the fact that they are not 100% judicial officers, they still are able to exercise the powers of a high court judge. Sorry. Moving forward, I would like to mention that an arbitrator is empowered only to resolve the issues which are submitted before him, as defined by the contract or by the arbitration agreement. I want us to understand this, that and I've made a note there that the powers and jurisdiction of the arbitrator are limited. And normally these powers and jurisdiction, they are limited by, number one, the Arbitration Act, number two, the contract between the parties, number three, the agreement between the parties, and number four, the arbitration clause, which is within the contract. I want us to understand that to go to an arbitration, if you have two parties within a contract, you do not necessarily, okay, one way is to have an arbitration clause inside the contract at the start of the contract. When you are signing your contract, say it's a construction contract between a client and a contractor, when the contract is being packaged, usually it will have an arbitration clause, especially if it's aligned alongside the established forms of contract like FIDIC and JBC. Now, it's important for us to remember that the arbitration clause is one of those clauses that have got life beyond the contract. Basically, what I mean is that the contract can die. You can sign a contract with a client and a contractor and cancel the contract or terminate the contract for whatever reasons. The termination of the main contract does not mean that the arbitration clause is terminated. The arbitration clause remains, it continues to have life beyond the contract for a simple reason, because it usually says that any dispute arising from this contract shall be subjected to arbitration. In other words, when you terminate the contract, that arbitration clause remains active so that the other party who suffered the termination still can rely on that clause of arbitration agreement to bring up any complaints or any dispute for arbitration, and that dispute will give the arbitral tribunal the powers and the jurisdiction to hear the matter, despite the fact that the contract itself was cancelled. The arbitration clause remains alive. In some contracts where there is no arbitration clause, the parties are still free. Even at the time when the dispute arises, they are free to agree that their dispute should be referred to arbitration. And there are methods that they can embrace to select an arbitral tribunal or a panel to listen to the dispute so that the dispute can be solved in a manner that they would prefer it resolved, normally away from the courts. In this case, the arbitration laws gives guidelines on how the parties can agree on the arbitral tribunal. I want you to understand that it's preferable, especially in construction contracts, in civil and structural engineering contracts, to have the arbitration agreement embedded in the contract. Because traditionally, when people are signing a contract and everybody's thinking, I will make money out of this contract, another one is thinking that I will do this project and I will again do business from this project. At that point, everybody is happy, everyone is smiling at the other, everybody has so much goodwill, and it feels just right to include the arbitration clause when everybody is in those moods, because then there is not so much friction between the parties. But if the clause is not included and parties proceed into a contract and get into a conflict, normally things become very complex when people are not seeing eye to eye at that point when a dispute has been declared and when the parties are now in a full-blown fight. It becomes difficult to choose who the arbitrator is going to be. And many times you'll find such arbitrations will take off in a very, very rough manner. And even after the arbitral award has been granted, you will most of the times find one of the parties, especially the party that loses, proceeding to court to appeal the arbitral award. And therefore it's advisable that when you are crafting your contract at the beginning, when everybody is still happy and all the parties are still warming to each other, include an arbitration clause which gives powers to, which builds consensus between the parties, to give powers to an arbitrator to listen and to determine any disputes arising from the contract. And it also defines jurisdiction. I want us to understand the logic of jurisdiction. Powers basically is to, the best way to understand the powers granted to the arbitrator is, there is this story of Moses in the Bible when he found two of his brothers fighting each other, and he told them that, you guys, you should not fight each other. The other day an Egyptian killed an Israelite, and I don't want to see you brother and brother fighting. One of them asked him, who gave you powers over us? In arbitration, the person who gives powers to the arbitrator is the party agreement. When the two parties agree to subject their matter to the arbitrator, they give the arbitrator powers. But then there is a separation between the powers and jurisdiction. You can be having powers to listen to a dispute between two parties. They've said, yes, you will listen to a dispute. We are engaged in a contract to construct a 20-story building, and we are saying that when we have a dispute over this building, so-and-so is going to be the arbitrator to listen to a dispute. Despite having those powers, the arbitrator must act within jurisdiction, because the contract or the contract clearly defines what the contract of construction of 20-story building involves. When you are given the dispute, when the dispute is submitted to you as the arbitrator, your jurisdiction ends with that construction contract. You cannot, for example, say that because these two parties gave me powers to hear them, because they agreed that I will be the arbitrator, therefore I'm going to determine why party number one fought with his wife at home. The fight between the party number one, or say the fight between the claimant and his wife at home, is outside the jurisdiction of the arbitrator. It has nothing to do with the construction contract, where parties intended to submit their disputes before an arbitral tribunal. So jurisdiction basically just defines the limit, the extent to which the arbitrator can go to as far as the disputes are concerned, and the arbitrator has got no ability or jurisdiction to determine any matters which are outside the purview of the contract. If the dispute is about a construction of a 24-story building which stopped, say, at 15th floor, and there was no money, and it stalled because of reason X, Y, Z, the arbitrator has only jurisdiction to determine the matter as far as the construction contract is concerned, and as defined by the clauses of the contract that gives him jurisdiction over the dispute that has been submitted before the arbitrator. I had already mentioned this, how matters are referred to arbitration. One, the parties can voluntarily agree to submit the matter to arbitration. And secondly, and when the parties voluntarily agree, either they can agree before the dispute happens, that is by including a clause in their contract, or even after the dispute happens, if they did not have any arbitration clause in their contract, they are still free to proceed and voluntarily agree to subject a matter to arbitration. Secondly, we have matters are referred to arbitration by statutory reference, where the disputing parties may be forced to go to arbitration because the disputed matter is covered by an act of parliament, which provides that such disputes be settled by arbitration, therefore boosting jurisdiction of the court in that matter. Basically, we do have some legislations which are passed by parliament, and they could be, for instance, the laws that govern employment, industrial relations. These laws are passed by parliament, they are acts of parliament, and every person working within that framework is bound to act according to the laws of the land. In such a case, when they have a dispute, when a dispute arises under such conditions, because the statute, the existing laws require that the dispute should be submitted to arbitration, the parties have got no locus standi to go to court to canvass the matter in court. Because even if they were to go to court, the court will normally refer them to item number 3. The court will send them back to arbitration. So the other way that matters can end up in arbitration is where an action has already been taken in court, but then the court, in their own wisdom, they issue orders that such a matter be subjected to arbitration. At this point, I want to mention, perhaps again in connection with the issue of jurisdiction, that arbitration has got, arbitrators can preside over mostly commercial matters. Arbitration has got no powers or jurisdiction to preside over matters of criminal nature. So you realize that even those matters which are referred by the court to arbitration normally are matters of civil nature, or matters, either they are about contracts, they are matters they are commercial matters, as opposed to if somebody committed rape, where it falls under it's a criminal act. If somebody steals, if somebody murders, if somebody robs another person, such kind of acts can the only person who has power and jurisdiction to hear them is the court, depending on the size of the offense and according to the rules of procedures of the courts. Quickly, I wish us to look at some basic definitions, which I have already gone over. Arbitration agreement, it's an agreement by parties to submit to arbitration all or certain disputes which have arisen or may arise between them in respect of a defined legal relationship, whether contractual or not. An arbitration agreement may be in the form of an arbitration clause in a contract or in the form of a separate agreement. A dispute is a difference which arises when one party makes a claim, the other party does not agree with that claim. Because they do not have a convergence, a dispute arises. And when a dispute arises in the context of our contracts, construction contracts, normally one of the parties who feels offended in most cases will issue a notice to refer the matter to arbitration so that the other party is aware which direction the one party is wishing to take. I want us to take some few minutes and now focus on the process of arbitration. When a dispute arises, when two parties fail to agree or to take a common stand on a matter, one of the parties will issue a notice referring the matter to arbitration. But I want us to appreciate that despite the fact that arbitration itself is a quasi-judicial process, it still follows the steps which are followed in court as far as the procedures are concerned. Normally, when we are doing filing of documentation in arbitration, it's more or less the same way documents are filed in a court of law. When we are doing, when we are serving notices, it's done more or less the same way it's done in a court of law, only that the civil procedure rules are eased a little bit to allow persons who are not necessarily admitted on the bench or on the bar to conduct these activities. First, a claimant initiates an arbitration by filing a statement of claim that specifies the relevant facts and the remedies. This means that if I am offended, I'm supposed to file a claim. And normally when I'm filing the claim, this claim will be filed to the party that I'm disputing with, or it will be filed to, if our arbitral agreement had asked us to refer our disputes, say, to ICC in this case, not International Criminal Court, but say the International Chamber of Commerce, or if we say we are going to refer to Chartered Institute of Arbitrators Kenya branch, the claimant is going to prepare a document. And what is in the document is, what are the issues the claimant is claiming, number one. And secondly, what are the facts? What are the facts that the claimant is bringing forward? And what are the remedies that the claimant is seeking? Okay, the claimant says that my contract was terminated unprocedurally by my client, and because of that, I'm seeking to be compensated for loss of revenue, idling equipment, blah, 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 and he normally quantified. The respondent also responds or he answers to the claim by filing an answer that specifies the relevant facts available in his defenses and to this, making a response to the statement of claim. After that point, once those two documents have been exchanged, now the claimant has made it clear what he is claiming, and the respondent has made it clear, has given answers to those things that are being claimed. Okay, you said that I terminated your job, I terminated the contract unprocedurally, or I unilaterally terminated the contract. As a respondent, the respondent could say, fine, I terminated the contract because you abandoned site. So he cites his facts in response to the claimants. At that point, an arbitrator is supposed to be appointed once those two documents have been exchanged. An arbitrator is supposed to be appointed because these parties are looking at one matter at two different standpoints. They don't seem to agree, they don't seem to have a convergence. If they proceed and discuss and have a convergence, that cannot be an arbitration. Instead, that becomes a negotiation between the two parties, which is part of alternative dispute resolution. It will save them time and money. But in case the parties are not able to agree, the parties receive lists of potential arbitrators and they select panel to hear their case. This is, for instance, if the parties were expecting to get an arbitrator from a body, say at the Institute of Chartered Institute of Arbitrators, or if they are expecting to get an appointment from Institution of Engineers of Kenya. So they will be given names. If the chairman of Chartered Institute is proposing an arbitrator, he will write to the arbitrator nominating the arbitrator, and he will copy the same information to the party so that if there is any party that is objected to that arbitrator, they can raise the matter. Ultimately, you need to realize that in arbitration, party agreement is supreme. If both parties agree that we do not want this arbitrator, then the arbitrator's work ends there. If one party agrees with the arbitrator, the other party does not agree with the arbitrator, they can always raise the issues with the appointing authority, and the matter can be settled at that point. However, if the appointing authority goes ahead and appoints the arbitrator, then the disputing party, the party who does not agree with that particular arbitrator, they only have the option of objecting to that arbitrator, to the arbitrator himself, under the doctrine of competence, as enshrined in the Arbitration Act. The arbitrator then can listen to the reasons given by the disputing party, and he can give a determination. He can decide. He has the competency to decide on his own competency. But when he's doing this, he must also take cognizance that he must remain impartial, and he must give an award that cannot be challenged in a court of law. And that's why if the parties raise valid grounds that compromise the position of the arbitrator, then it is always wise for the arbitrator to give way, recuse himself, and allow the proceedings to go on. Okay. After the appointment, the arbitrator will hold a preliminary meeting attended by both parties. Normally, it can be physical or it can be virtual. The claimant and respondent by the representative, or which he will become familiar, the arbitrator will become familiar with the nature of the dispute. He will also give directions as to the conduct of the case, its timing, including preparations of claims, respondents' answer to the claims, any counterclaims, and such kind of information. Now, at this point, I want to bring it to our attention that the arbitrator, once he has been seized of the matters under dispute, the arbitrator is what we call him, he's a master of the procedure. It is the arbitrator from that point who begins issuing orders and directions. He telling, the same way it happens in court, you tell the parties, you will appear on this day, you will do ABCD, so and so submit your statement of claim on this day, so and so submit your response and your counterclaim, so and so make your submissions, blah, 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 blah. From that point onwards, when the arbitrator comes on board, he needs to take charge of the procedure. We call him the master of the procedure. But even at that point, we need to remember that party agreement still remains supreme. Suppose the parties agree and say we do not want to continue with this arbitration. If they agree, then the arbitration cannot go on. If one party wants the arbitration to go on and the other one doesn't want the arbitration to go on, then the arbitration will go on. The only thing that can change situations is if parties agree to take a different direction. Okay. Now, once the parties have been ordered by the arbitrator to make submissions to exchange documents, that is their statements of claims plus every material that they're relying on as proof, whether it is any physical objects, whether it is letters, copies of letters, the arbitrator directs the parties to exchange all these documents so that the claimant, all the materials he's relying on are supposed to be given to the respondent, and the respondent also, all the materials they're relying on, the letters, the daily inspection reports, and what have you, are also handed to the claimant. Plus, if there are any counterclaims, they should also be backed up and be exchanged to the claimant. At that point, the procedure of this, at that point, the arbitrator can proceed to conduct a pre-hearing conference. The purpose of pre-hearing conference is to enable parties to prepare, just set the date, set the time, set the location, set whatever it is that should be exchanged at discovery. Okay. After pre-hearing conference, the parties are supposed to swap. Sorry, I think I had skipped the pre-hearing. You go to pre-hearing conference and then you go to discovery, where the parties now exchange the full materials before you proceed to the hearings, where parties can now make their submissions before the arbitral tribunal. I want us to appreciate that not all arbitrations will go to oral hearings. In some cases, some arbitrations, especially what we call documents only arbitrations, instead of holding oral hearings, either virtually or physically, the arbitrator can issue orders, and this is usually subject to party agreement. The arbitrator can issue orders for the parties to make their submissions. Now, the difference between statements of claim and these submissions is that under the submissions, the parties can now make arguments. The facts that I laid out are these. The law that is applicable to those facts is this, and what I'm claiming out, the remedies that I'm claiming out of it is this. We are relying on this law, we are relying on this case law. When this dispute came up before court XYZ, this is how they determine. So the parties will lay out their arguments in written and exchange the arguments to the claimant, sent of course through the arbitrator, to the respondent, and the respondent also responds to those claims, sends them through the arbitrator to the claimant. But in case the arbitration is not a document-only arbitration, then the parties will go to, and during full hearing, just apart from making the submissions, the parties are free to call in witnesses. The witnesses will be examined in what we call examination in chief. If I am the counsel representing the claimant, I will call in my witness. I will examine him, what we call examination in chief. Once I've examined him, and we need to remember examination in chief, there are rules that apply on how to conduct an examination in chief. You do not just ask any questions. The questions you ask must be open-ended questions that are not leading questions. You cannot ask somebody, okay, you are here representing company XYZ. Were you on site on 15th of November? You know, when you ask such a question, the witness can only say yes or no. Basically, it's a close-ended question. It's a leading question. In examination in chief, you can only ask him, where were you on 15th? So that the witness is able to give an open-ended answer, not a yes or no answer. However, once examination chief is complete, the witness is subject to be cross-examined by the counsel or by the other party. Say the respondent now examining the claimant's witness. During cross-examination, leading questions are allowed. Like, Mr. So-and-so, you said that on 15th you are on site. The answer is yes or no. You said that morning it was raining. The answer is yes or no. So cross-examination can proceed along those lines, leading the witness to head to a certain direction. And sometimes it can get a little bit rough for the witnesses. That's why it's important to prepare witnesses if you plan to present a witness before any arbitral tribunal, and of course, before any court proceedings. The respondent also does the same. If they have any witnesses, they will present them. They will conduct an examination in chief. They will allow the witnesses to be cross-examined. And if there are any counterclaims, the procedure always keeps on taking the same path. The respondent on any counterclaims and any witnesses they will have to present, but then the claimant must have their chance to give their side of the story, ask their questions, and then the final person to make closing remarks is the person who started making their presentations. After the hearings have been done, after the submissions have been done, after the witnesses have been examined, after evidence has been adduced before the arbitral tribunal, the tribunal can now retreat and make a decision and draft an award. They can either draft a reasoned award, or sometimes you just draft an award. You just say so-and-so is entitled to 50,000 shillings. Many parties prefer that the award should be reasoned, so that the arbitrator must state, these parties came before me, these were the issues, these were the arguments, and from the position of the arbitrator now demonstrates his reasoning and says, from what I listened to and considering these laws, I think this and this and this is valid because of reasons X, Y, Z, and therefore he issued now his final award. Therefore, you are supposed to pay party X 50,000 shillings. That is allowed during issuance of the decision and drafting of the award, which usually pronounces the end of the arbitration procedure. At that point, the arbitrator can, when he gives the awards, he can, within the award, it will be clear who is entitled to what and for what reasons, and the parties can now collect the award. Something beautiful about arbitration is that the laws of arbitration gives the arbitrator lien on the report. So after he has finished issuing his award, he needs to be paid his money fully, and then the parties can take the award to act on it, or perhaps to register it in court for action if whatever directions, whatever decision the arbitrator has made, if it cannot be enforced by one of the parties can seek the court's assistance in enforcement. I want to rush quickly on arbitration in the construction industry. Arbitration in the construction industry, I need us to appreciate that arbitration is recognized as the dispute settlement mechanism in construction industry due to its known advantages, which I've already gone through them. And most forms of contract, they specify arbitration clauses, both FIDIC, JBC, and any other form of contract in construction industry. They have always been sensitive to the need for arbitration. And you realize the clause on arbitration is usually given a lot more details so that there are no many gray areas. Construction contracts are always susceptible to disputes. And the larger the contracts, I realized that the more complex the contracts are, the larger contracts are, the more susceptible to disputes they are. And it is no surprise that some contracts, actually most contracts, begin with a dispute. If you've not noticed that, perhaps you'll be noticing it along the way. Now, in the construction industry, looking at the contracts that we handle, regardless of which forms of contract you're relying on, whether you are in infrastructure projects or building projects, the agreements, they have naturally they have three facets. Number one, there are the enforceable promises which have been made in the contract. I will do this, I'll be paid this by this date, because we have the approved work programs and what have you in the contract. Then there are technical matters, which usually are guided by technical specifications. And finally, there are legal matters as a key aspect of a construction contract. Like any other contracts, building contracts are concerned with making promises with expectation that one can be forced to carry them out. And that's why this is outlined in the contract. Where there is a difference of interpretation, then the type of contract will be important in determining the way in which the contract will be interpreted. And if it's not a standard form of contract, because in some cases we have bespoke contracts, or we did not apply, despite the fact that we are engineers, you will still find some of us getting into contracts which were not per se drafted based on FIDIC forms of contract and what have you. If you find yourself in such a situation, because I know many people have found themselves in such a situation, it doesn't mean that you are not a professional. It just means that you didn't do something important. But then when disputes arise from them, we usually apply the doctrine of contra preferentum. It will prevail in such a case. It means that any ambiguity in a contract will be construed against the party who seeks to benefit by exclusion or limitation in it. If an item was left, there is an ambiguity in a contract, one way that we can determine who is supposed to take the blame is by looking at who is supposed to benefit from that ambiguity. Then you would realize that in most cases, they are the ones who are supposed to shoulder the blame. Disagreements arise over technical questions in a contract. The use of different techniques is often a cause of disagreements and arguments, and adequate site investigations are a constant source of problems in the industry. It is depressing to realize how many clients are shocked at the extent of their liability for site conditions. I think I've been through dispute resolutions for disputes that arise from technical matters. One, maybe I can give two examples. One where a contractor travels to an arid place to drill a borehole, and the contract is not very express about the method to be used. He leaves and goes there planning to use air compression for drilling. But after he drills up to 250 meters, where he was told that there will be water from a hydrological report, he finds out that he has not struck water, and air compression can no longer take him beyond that depth because the formation is also a bit loose. Therefore, he's now losing air circulation. He's losing air. When he pumps the air into the borehole, it cannot blow out the cuttings because a part of the air, big quantity of the air disappears into the rocks because of the loose material down there. So he realizes he needs to change the method to mud drilling. And because of this change in technical requirements alone, it precipitates into a dispute. Second case, a building contractor who, there is a developer on one end, there is an architect, a designer on another end, and then there is a building contractor. The architect designs, the QS develops the bills of quantities, they make promises to the developer that with this amount of money, we will be able to build this building and complete it. The building is supposed to be, say, 20 floors. By the time it is on 7th floor, you still have 13 floors to go, and all the money is finished. When they come back to the drawing table, they realize that the site investigation that was conducted was not adequate, and therefore they spent a lot more money in the foundation. The money being used for the project is borrowed from a bank. The bank is expecting their money. The project is hardly at 50% complete, and everything goes down the drain, and it precipitates into a dispute. We do have such technical matters on projects that can always push a project into dispute, and there are issues that have to be guarded when people are entering into contracts. And of course, we have legal matters, and the legal matters usually will be based on the laws of the country where the project is being performed, or on the laws where the parties have agreed. I just want to throw us back to the question of jurisdiction. If a company is doing a business between a Kenyan company and a Tanzanian company, and they get into a dispute, the courts in Tanzania have got no jurisdiction to prosecute a Kenyan company. The courts in Kenya have got no jurisdiction to prosecute a Tanzanian. And the easiest way for these two parties to solve their disputes, because it's a cross-border dispute and it's a dispute that spans different jurisdictions, they can subject the matter to an arbitration, and the arbitration has got such kind of flexibility to expand its jurisdiction as long as it covers matters within the contract for it to be determined. But the beauty of it is both parties can choose which law to apply. It can be a dispute between a Kenyan company, a Tanzanian company, but they say the laws of England shall apply. Whatever it is that the parties have agreed, that is the law that will be applied. So when someone is looking at this contract and this dispute and he wants to consider matters of law, he will be looking at the laws that the parties have agreed to go by in that contract. But we need to realize the law is not infinite. The law doesn't cover everything that happens. The law cannot cover every day-to-day occurrences. And because of that, there are some gray areas within the laws that will precipitate a dispute, and these disputes must then be subjected to a competent institution which can interpret those laws correctly, apply them to the situation at hand, and make a determination impartially and within the time that is provided for as agreed upon by the parties. Now, in doing this, the arbitrator or the person making the determination must be able to examine the facts and establish what is it, who is entitled to what. And once he has established the entitlement, he should also be able to establish what is the magnitude of that entitlement. Okay, so we can say in the case of professionals failing to conduct a site investigation, leading to all the resources getting consumed in the project, we can say, okay, who is entitled? The developer is entitled to recover his costs from the professionals who failed to do their job. Now, we know that he's entitled, but we have also to answer the question of, he's entitled to be compensated by, but what is the magnitude? What is the quantum of what it is that he's entitled to? In another case, you say the contractor was terminated unprocedurally, or the contractor is entitled to get to a claim of extension of time of 3 months plus the costs. But you have to establish, what does that mean? How much does that translate to? What is the magnitude? Okay, while he's entitled to 3 months, he lost 3 months because the designer did not issue him with the technical drawings, or he did not issue him with the work instructions. He lost 3 months, and by losing 3 months, it means he had equipment, grader, he had an excavator, he had a roller on site. All of them were in working conditions. The dry rate is this per hour. You quantify the number of days, the number of hours lost, the rate per equipment. You quantify the rate for personnel. and you come up with a figure, an amount, demonstrating the magnitude of what the party is entitled to. In finishing up, I think I'm going toward the final slides. I just wanted to highlight some of the causes of disputes in construction projects, and I think I've already mentioned some of them in passing. One needs to appreciate that the construction industry, just like other industries, involves human relations and interactions, and disputes will arise in practically any aspect or area. The main types of disputes that often end up in arbitration are issues like suspension of works by either party, disagreement between the contractor and the client, or the architect or quantity surveyor, okay, on the final account. One person claims I'm entitled to be paid this, another person claims you are not entitled to that, you're entitled to less. It precipitates into a dispute. Failure by the architect or engineer to issue certificates to the contractor, claim by the contractor for extension of time, claim by the contractor for additional losses and expenses, termination of the contractor's employment. All these are scenarios that can precipitate into disputes on our construction sites, and there are issues that we must look out for during execution. Normally, when I say we need to look out for, this is what I mean. Whether you are a contractor or you are a supervision consultant, you are the professional on the project, you're the engineer, you must be vigilant, you must do proper documentation, especially basic things like, issuing of instructions, issuing of technical drawings, making decisions at site in a timely manner, timely communication at site, taking site records like daily records, daily inspection records, measurement sheets, and having them countersigned on each day, showing the details of what is happening each day, because these are the documents that will go into determination of these disputes. These are the documents that will form your basis of either your claim or your basis of rebuffing whatever claim that will have been brought up by any other party. We have some, just want to highlight some potential areas or causes of dispute in industry that can be classified into 5 main areas. The areas where disputes can arise in an industry can be classified either as poor contract documentation, when you have some clauses not properly structured, or maybe you have clauses that are in conflict with other clauses, a document that is not communicating with itself, it is possible to end up into a dispute. We have had this scenario with it does not only happen with contract documentation, but even our own. I think right now as an institution, we are trying to revise our constitution. And one of the things we are fighting with is we have clauses in our constitution which are in conflict with other clauses in the same constitution. Because these contracts are developed by human beings, these documents are written by human beings, and human beings are not all knowing. Sometimes they can make mistakes, and sometimes they can prepare clauses, forget maybe another clause. In fact, in this generation, we have a problem of copy pasting. You copy paste, but you do not give yourself time to read every clause. You end up with some clauses in conflict with others. That is always a place, it always creates potential for disputes. Breach of contract terms and conditions. The conditions are there, the terms are there, they are clear, but then someone else, either out of omission or commission, or out of ignorance, they just fail to adhere to those contract terms, and they make another party to make losses because of failing to adhere to the contract terms. That is also another area that yields potential for disputes. Then we have bad or adverse administration and execution of contracts. I had already mentioned earlier, when you have someone who is administering a contract, but he's not capable. I actually came across one contract where there is a resident engineer in charge of a contract, but he is not capable of issuing site instructions, telling the contractor what they are supposed to do, as he is this is what the contract requires him to do, but he's not able to do that. So what he was doing is he would ask the contractor to draft instructions to himself, and then the resident engineer only signs them off. This exposes the contract administrator so badly that many times down the line, he'll find himself fighting with instructions he would otherwise have not given if he was doing it out of his own sane mind. And for that reason, bad or adverse administration of contract, sometimes failing to take those daily records, sometimes failing to have the records duly signed or countersigned between parties, sometimes failing to communicate in a timely manner. You discuss something, you go keep quiet about it, you do not communicate in written, time passes by, and you only remember to communicate when a dispute has arisen. Those are bad or adverse contract administrative issues that many times can precipitate disputes. We have variations, changes that do come into the contracts, and also claims that generated from the contract will always portend disputes. Anytime it comes up, normally it will be viewed differently from two different perspectives. I think I wish to, because whatever is coming down in those other slides is basically what I've already discussed. And I will go straight to the final slide 23, which says thank you, and allow for question and answer. You might notice that we have slide 24, 25, and 26, but what these slides are doing are just to give us a glimpse into the Arbitration Act of 1995, which governs arbitration in Kenya. I will allow us to take questions. I think I've done about 50 minutes, and Dolo, we can perhaps take a few questions.
All right, thank you so much, Engineer, for those wonderful points on arbitration in general. We have some few questions here. I will start by asking some, and then Lawrence will take over before we come again. Now we have several questions on how to become an arbitrator in Kenya.
So, to become an arbitrator in Kenya is a simple process, which is first, you need to attend an entry course at the Chartered Institute of Arbitrators, which takes it's 3 days nowadays. It's a course for 3 days. You sit an exam and you can become an associate of the Chartered Institute of Arbitrators. And you can then follow through to do module 1, module 2, to become a member of the Chartered Institute of Arbitrators. So it goes stage-wise. Then module 3 and module 4, and award writing, you become a fellow. It's a fairly straightforward structure, but saying straightforward doesn't mean easy, because at some stage, module 1 normally almost 95% of everybody passes. No, not module 1, but entry course, sorry. But when you begin going to module 1 and module 2, the work that you have to put in is a little bit more. And because of that, you need to prepare yourself for quite a bit of work. We had a class of 13 and only 2 passed. And out of the 2, one of them was repeating. So that tells you the success rate, especially as you continue going upwards. However, this should not discourage anybody, because those things that to see people being members of the institution and fellows, it means that they have sat those exams and passed. So those exams you can receive the training, sit those exams and pass them. Normally, engineers, people from technical fields will find it easy to sail through. I don't know for what reasons. Yes.
Yeah, somebody is asking whether this is can it be a part-time thing, or it has to be a full-time thing?
It can be part-time, especially in the Kenyan case. The industry in Kenya has not generated enough disputes for someone, for example, to be doing that dispute resolution 100% of the time. But if you went to big markets like, say, China, someone whose work is only arbitration has his hands full, and they have nowhere else to take their job to.
Right. Do we have such companies in Kenya, like civil engineering companies, that dealing with just arbitration, who can mentor graduate engineers or young engineers?
I've not heard of civil engineering companies who do 100% arbitration in Kenya, but I know there are individuals who do arbitration, and the Chartered Institute of Arbitrators has got a very good structure for mentoring. If I have any arbitration case, anytime I do any arbitrations, I always have an intern, not really an intern, but a mentee, both a technical mentee and a legal mentee.
Nice.
So for any case, if you're appearing as a sole arbitrator or as an arbitral tribunal, we always must have a mentee. And at the end of every arbitration, you must submit a report to the Chartered Institute of Arbitrators.
I see. Then there is a question regarding international companies. Say a company is working in Kenya. Does it mean that the company cannot be charged in the country's court of law?
They can be charged. They can be charged in the country's court of law, but as I had mentioned, there are challenges of doing cross-border litigations, because when you charge the company, you will be charging them because perhaps the contract is being performed in Kenya. The company is a foreign company performing a contract in Kenya under the laws of Kenya. Okay. Of course, if there are any matters of criminality, then they will have to subject under the laws of Kenya. But if there are any matters of commercial nature, the two parties are free, because this is the logic behind it, Ndolo, that the laws of China might not be very fair to me as they will be fair to a Chinese.
Yeah.
So when we find ourselves in that situation and we are doing business between me and a Chinese, it is within our powers as parties to agree that when we have commercial disputes between ourselves, instead of me taking my Chinese client to a Kenyan court or taking my Kenyan client to a Chinese court, we can subject our dispute under the commercial terms to an arbitration, and we will apply the laws of Kenya, or we will apply the laws of England.
That means you have to choose which laws you want to apply.
Yes,
the two parties.
Yes, the two parties should be free to choose the laws that will apply. But this is just to ensure that each party feels like they have been treated fairly. Because arbitration, you see, litigation usually is a system of absoluteness. Litigation, it is either you are this side or that side. But in arbitration, it tends to do the Solomon thing. We split the kid so that everybody gets which portion belongs to them. Something like that.
Right. Lawrence?
Okay. There's one question here. Someone is asking when a contractor is awarded a contract, for example, to construct a box culvert that is worth 4.5 million. The contractor then goes ahead to enter into a contract with the client, then provides a 5% performance bond. But after the completion of the project, the contractor realizes that a quarter of the quantities as described in the BQ is not used. So the question becomes, does the measured work supersede the contract, or how does someone tackle such an issue?
It depends really. First, I will not see this as an arbitration issue, but let's assume it is. It really depends on the type of contract that they signed. If it's a unit rates contract, I need us to understand that unit rates contracts do not have a contract. They do not have a contract sum or contract duration. Contract sum is what will be at closure of the contract, when they've finished doing everything. The figure that will have been paid is what becomes the final contract sum. And the duration that they will have been on site is what becomes the duration for the project. I wanted to draw this distinction between a unit rates contract and a fixed sum contract. If it's a fixed sum contract that someone signed, the fixed sum contracts that it says that, I'm going to give you a box culvert at 100 million. In that contract, it's usually clear that the bill of quantities, actually it's specified, it's usually stated that the bill of quantities, it's usually called a non-binding bill of quantity. So whether the contractor exhausted all the items on the bill of quantity, or whether he performed only a quarter of them and the box culvert is finished, he's entitled to be paid the full amount if it was a fixed sum contract.
Okay.
But if it was a unit rates contract, he can only be paid for the quantities that he did. If it was 30,000 cubic meters, he can only be paid 30,000 cubic meters of concrete multiplied by the unit rate. Whether that brings it to 3/4 of the initial contract sum, or it takes it to 102%, that is what he will be entitled to be paid.
Okay.
It's a question of forms of contracting.
Okay.
Yes.
I think that is well understood. Then the other question someone is asking, I think this is a general question. What is the effect of the pandemic on the current construction projects and stock contracts in terms of claims? And then he's saying that a case study of his is a project that he's currently doing and is concerned about extension of time, where the financier is yet to approve the EOT, given the contract period is ending on 8th May. How can they tackle such an issue?
The issue of the COVID pandemic is really, really wide as far as it's affecting contracts. But yes, I agree that it's affecting performance of contracts, because when workers are not able to move, when materials cannot be moved, when there is travel restrictions, certainly it affects the contracts and it makes it difficult for contract performance to proceed. And this is certainly going to end up into claims for extension of time and claims of related costs for those EOTs. When this arises, I believe it will have to be evaluated case by case, because like in this case where somebody is asking for EOT, you see, even if you ask for EOT and the time for performance of the contract is ending in the next 2 weeks, yet the event that is causing your application for EOT is still going on. There are two scenarios that the employer can do. Either the employer can give a provisional extension of time, but they might not be able to quantify exactly how long COVID is going to affect the contract. Because we might get to the end of next week and the CS comes and announces that he's adding us another 21 days. So for as long as the event that is causing the claim for EOT is still persisting, the employer is not able to give a definitive extension of time to that contract, except either allow the contract to become at large and then they will evaluate and award, or they could give a provisional extension of time just to continue observing the situation, and then we'll evaluate at the right time, give the final position, and agree on a way forward.
Okay.
Mention that the situation of COVID, someone was making presentations recently that it precipitates a scenario of force majeure. It is something that nobody caused it in the contract. So even though we might have claims for extension of time, it cannot be to the benefit of the contractor at the expense of the client.
Of the clients.
Because it's affecting both, and it's not by the doing of either of the parties.
Okay.
Yes.
Then there's one other question from a member, Cedric. He's asking, does improper procedures in claim filings with respect to documentation and timelines invalidate the veracity of the claim to be ignored in totality or administered differently? Hey, proper English, eh?
Yes, tough English. What I need to inform members is that in arbitration, more, and I think even the court in recent past, especially if you check the ruling of Justice Maraga during the second last presidential petition, normally the courts were giving a lot of prominence to matters of procedure, so that because you did not do this thing by this minute, therefore it invalidates everything. We can no longer listen to your case. Now, arbitration does not take that direction. Arbitration usually seeks to respond to the substantive matters as opposed to sticking to procedural matters. That does not mean that arbitration doesn't care about procedure. It still cares about procedure, but whatever procedure that is adopted must be fair. It must demonstrate fairness, impartiality, but it has also to be expeditious. Today, arbitration, I think arbitration was flexible enough to navigate beyond the tight court procedures when COVID happened, so that immediately the Chartered Institute issued out guidelines of how to conduct arbitrations in virtual. The courts have now, in the last 3 days, I heard that now courts might be considering to go that direction. But we must remember that arbitration has embraced a bit of flexibility, and whereas arbitration respects procedure, it does not necessarily exalt procedure over substance.
Okay. So it basically means, sorry to cut you short, basically means that, say for example, a QS maybe missed a few quantities and the contractor comes and claims, it means that we will not, in arbitration, will not look at the issue of the QS missing the quantities, but rather what what the contractor is claiming is what actually the work that he did. Is that what it means?
No, I think no, it doesn't mean that. What you've mentioned, what you've mentioned is not a mere matter of procedure. What you've mentioned is what you've mentioned is a matter of substance.
Okay.
I'll try to explain. A matter of procedure is, you said that the QS forgot to capture some information in the contract.
Yes.
Now, that's a matter of substance which should be determined by the arbitrator, okay? The things I'm calling matters of procedure is whether the contractor filed the case within 3 days or 7 days, okay?
Yeah.
And whether the quantity surveyor responded within 2 days or 5 days is neither here nor there.
Okay.
Procedure is the procedure of running the arbitration itself. Because the arbitrator normally is, we call him the master of the procedure. If we had said that, if I had issued orders and told the parties that I want the claimant to file his statement of claim within 7 days, okay? And then 7 days after that, the respondent to file his response and his counterclaim. Suppose we get to the 7th day and the claimant has not filed his claim, I will not hang on to that breach of procedure to dismiss his claim. No. As the arbitrator and as the master of procedure, perhaps I could issue him another order and tell him, I asked you to submit your claim within 7 days. Today is the 8th day. I have not seen your claim. I'm giving you 3 additional days. And if you fail to submit, I shall assume that whatever letter I receive is everything that you want to submit. You get my point?
Yes, I understand.
Because that is now a matter of procedure. But something, for example, a clause that was left out in a contract, a quantity that was not captured, a clause that was captured in conflict with another clause, those are substantive matters.
Okay.
The arbitrator has to address himself on those matters and determine those matters.
Okay. I think that is perfectly explained. I am seeing no other questions from the members. I stand
have
guided
one.
by Ndolo. Okay.
Yes, brother.
I have one. There's one was sent via email. It's a bit long. I'll have to read it. I have a project that has run out of contract period as an ER. The client has awarded extension of time. The contractor has not embarked on the works. Upon scrutiny of statutory documents, that is in bracket, performance bond, insurance policy, and advance payment guarantee have all expired. I have instructed the contractor for validation of the same, but not yet availed. The catch is the engineer has issued a notice to terminate the contract, which now leaves me in a quagmire. If the project is terminated, the client loses all because of expired documents. The contractor is now not interested to validate his documents. I'm left to determine and advise. what are the necessary steps that I should take? Arbitration is inevitable due to non-performance by the contractor.
Without going into details, I think the scenario being painted is the scenario of, it's a scenario of, the scenario of a client who is exposed contractually.
Mm-hmm.
Because the client has been magnanimous, he has even issued an EOT. If he has issued an extension of time, it means that the contractor is contractually safe. But unfortunately, the instruments that are supposed to protect the client, because the contractor is contractually safe, but then he's not mobilizing back to site to do the job he's supposed to be doing, which means he is in breach of the contract. Over and beyond being in breach of the contract, the client is incapacitated. He cannot liquidate anything because he has no insurance covers. He cannot go to the insurer to claim the money, or stuff like that. So what I'm seeing a contractor, I'm seeing a client who is in a catch-22 situation and who is so badly exposed. As the gentleman or as the lady suggests, this is a case that is actually ripe to go into dispute. The serious problem that they'll be having is how to recover, even if it goes to the dispute and the client finds himself to be on the right and he's awarded, it still becomes difficult to enforce that award or perhaps to actualize that award, because justice, if an order is issued giving justice to somebody, it is not enough to be legally right, but whatever it is, whatever orders that you've been given should actually give effect. You should be able to get something out of it. So it's a case that is ripe for arbitration. The good thing is that in arbitration, perhaps if the client gets awarded and he needs to make any recoveries, he might have to secure the site. If the contractor has got any equipment, any plant or whatever, he might want to consider to secure any movable assets or any physical assets by that contractor if he realizes that they are going to get nowhere with the contractor. The other alternative is they need to have a sit down, perhaps because now the client is at a disadvantage. It would have been better if the client had those instruments, those financial instruments that protect the contract. But if he doesn't have them, maybe he might want to explore diplomatic ways of trying to get the contractor back on board, either to give the financial instruments that protect the project or engage diplomatic ways to get the contractor doing the job. Establish why the contractor is not doing the job, try to fix that problem and get this guy back on the job doing it. Otherwise, the client is exposed. The client might be contractually right, to cite breach of contract. But even after citing breach of contract and winning, it becomes very difficult for them to effect any of the decisions or any of the awards that they might get, because they do not have any financial instruments to cover the contract.
All right.
All right.
Thank you for that. We don't have any questions. Do you have any questions on your side, Lawrence?
I don't have any more questions so far. No questions.
All right. I think to that point, we thank Engineer very much for this wonderful session tonight, and we hope to have more as we brainstorm in the future. Engineer, thank you so much.
Thank you so much, Ndolo, and thanks, Lawrence. Thanks, team, for spending time, being patient until very late, waiting to go through this session. I really appreciate it.
Thank you. Everybody, good night.
Good night.